There's a threshold question for S2109 for anybody that's concerned or interested or curious. And that threshold question is about your goal. What is your goal? Is your goal to maximize rights, or is your goal to minimize rights? Maximize, make them as large and as valuable as you reasonably can, or minimize, make them the least possible. That's how you define that. Who in here for the Navajos would maximize Navajo water rights? You have to go, me. Okay. Who would minimize Navajo rights? Nobody for minimize? Right. Let's go to the next one. It is a little dark, so I'm just doing much of this from memory. In your handout, you all have the next one, which says Supreme Court of Arizona in blank. Supreme Court of Arizona. There should be a little tab. It's blank. It's blank, like this. Should be a little yellow tab on the left side. There we go. I'm just interested in pages 30 and 31. That's what it says on the slide. Refer to pages 30 and 31 of the next handout, which is this one's Supreme Court of Arizona. The Supreme Court wrongly and narrowly used a minimizing of Indian water rights, and we'll explain what that means later, to severely limit Navajo rights, and that's being applied to S2109. The philosophy is being applied. On page 30, right below where it says at paragraph 47, just want to read that one sentence there with two sentences. It has orange around it. We recognize that the Supreme Court, they're referring to the U.S. Supreme Court, has rejected any quantification standard based solely on the number of Indians. However, if a federally reserved water right is to be tailored to a reservation's minimal need, as we believe it must, then population necessarily must be a part of the equation. My emphasis here, you all on your handouts have a green underline regarding minimal need. On the next page, we have a little orange bracket. It should start right after that when an Indian reservation is created. When an Indian reservation is created, the government impliedly reserves water to carry out its purposes as a permanent homeland. That is true. Then it says a reference to the Winters case. The court's function, their court, is to determine the amount of water necessary to effectuate this purpose, tailored to the reservation's minimal need. We believe that such a minimalist approach demonstrates appropriate sensitivity and consideration of existing users' water rights, and at the same time provides a realistic basis for measuring tribal entitlements. 109 uses the legal philosophy of this case, the Arizona Supreme Court case we just read a couple of things from. And it actually uses it a little worse than the Supreme Court of Arizona presented the philosophy. It's more narrow than the Supreme Court of Arizona presented. My purpose here is not to discuss the decision in great depth beyond the basics and the impression it leaves. We'll reveal what that means later on. Council was told the case was a huge win, i.e. a permanent homeland reservation purpose, yet the 1868 treaty, and I have a little marking on it right there where it's written out, the 1868 treaty already refers to the Navajo reservation as a permanent home, and it refers to agriculture. There are more than 20 agricultural references in the 1868 treaty. There's one, perhaps more, in the 1849 treaty. But things like agricultural allotments, seeds, cattle, corn, cultivation, farming, farmers, are repeated throughout the 1868 treaty. And again, the homeland. The court said Indians tend to get too much water the way things are. I'm going to say that again. The court said Indians tend to get too much water the way things are. And a, quote, minimalist approach to Indian rights was now necessary. Now, we're so used to hearing things that don't grab our attention. I have some members of my family who are black, African American. We talked about this, and they said, change the word to, the court said blacks tend to get too much water, the way things are now. And a minimalist approach to blacks' rights is now necessary. That is the impression that we're talking about. Too many times, too many decades, too many centuries, we've got so used to the Indians are less than philosophy from the Discovery Doctrine and elsewhere, that a court can write something like that and we just don't pay attention to it. And I'll explain that a little further. The dictionary definition of minimal is least possible. This is not federal Indian law, but a theory applied to American Indian people by the Arizona court, hoping it will catch on. It's been objected to in 2 federal courts successfully, this state court case. It was embraced here on Navajo, but it's protested elsewhere. It links right into S2109, today's NGS, and today's CMP issues. The only problem I have is it's so tiny. Go ahead. Move that over. Okay. The Navajo Water Rights Group's presentation handout, so on and so forth. NGS and the Upper Basin Water Rights Waiver of 1969. And this is Fradkin. After the coal, the water had to be obtained for the Navajo plant. This was accomplished in 1969 when the Navajos waived their rights to 50,000 acre-feet of water that had been apportioned to Arizona from the Upper Colorado River Basin. In 1948, the Indians were not party to the compact, nor had they taken part in the negotiations. The 50,000 acre-feet represented a bone that was thrown to them, since it was far less than what they could probably obtain in court under the Winters Doctrine. On December 11, 1968, the Navajo Tribal Council passed the necessary resolution, handed to the Tribal Council by a Department of Interior representative who had been dispatched from Washington, D.C. by Udall. It was later claimed the Salt River Project also had a hand in drafting the resolution, as did the Executive Director of the Upper Colorado River Commission. The Gallup Independent, May 31, 1969, further reported that the companies involved with NGS, for which the water rights were waived, was wanted. Well, it's so tiny, you wouldn't believe how tiny this is. Offered the new Navajo Community College a capital grant of $250,000 and a temporary endowed chair for $25,000 a year. Huge economic benefits at all levels were also promised the Navajos. And we'll finish on this one. It seemed a fair deal at first, but when they realized the extent to which they had been duped, the Navajos began making noises in the 1970s about asserting their full Winters Doctrine rights. They felt cheated by the federal government and its waiver water. I guess you read that clear. They felt cheated by the federal government and their water clientele over the deal to furnish Navajo power plants with water. The information that had been, or you can read it on the screen. Oh, please, please.
The information that had been available to the Tribal Council in of the resolution vote came from Salt River Project, the Upper Colorado River Commission, and the Bureau of Reclamation. All had a decided stake in the outcome that was not synonymous with the best interests of the tribe. It was not until a group of young activist lawyers with DNA pointed out the poor deal the Navajos had gotten that the tribal council had second thoughts. A paper prepared by DNA stated what had become the sad truth in the Southwest for the Navajos. In essence, then, the relationship between the Southwestern political power complex and the water rights of the Navajo tribe is this. Navajo coal mined from Black Mesa on the Navajo Reservation will be burned at the Navajo Generating Station on the Navajo Reservation in order to pump Navajo water from the Colorado River to Central Arizona Project. The disastrous water rights waiver is so utterly out of keeping with provable Navajo rights that quite probably it will fail if legally challenged. Law professor Lloyd Burton in his book Indian Water Rights and the Limits of the Law, 1991.
Thank you, Nicole. Okay, we're going to pick up speed a little bit. We've got a few more pictures instead of printing. This is the canal we all drive over on the way down there. Again, Navajo coal and Navajo water is pumping that water at some of the stations. They have pumps that have 5,500 horsepower, and they're banks of 8, over 40,000 horsepower at each pumping station pumping water, depending upon the elevation it has to go. Next one. This is Phoenix, Tucson down here, Lake Havasu, Bill Williams River. This is kind of a rough description drawing of how things work. That's a recharge project. They also bank water in the ground, excess water. We'll see how that works in a minute. But they have pumping plants, siphons, recharge projects, tunnels, and dams all along the 336 miles. Water banking is basically sinking water into the desert for later use or trading or selling or leasing. There are now 7 of these sites along 200 miles of the Cap Canal. Some of you have seen those. And Arizona has a water banking authority. It's not the only one, however. And they trade water with other states and do all kinds of deals. I'm only just learning from some of them what they do. There's a second banking program. It was created to establish a 100-year assured supply for 200,000 new homes in Arizona to keep the economy going. Surplus water that goes downstream is banked. Okay. The Arizona Republic has had 2 major stories on S2109 in 2 days. There must be something happening down there. The one from, this is correct, May 14th had very revealing quotes from Central Arizona Project General Manager David Modier and John Kyle. And I happen to have the abbreviated quotes right here. Now this is the CAP manager, and he's talking about why and how CAP became part of S2109. David Modier, CAP General Manager, said his agency had less reason to work on the tribal settlement after the Colorado, meaning the main Colorado claims, were removed, including the power plant leases, would allow CAP to contribute toward a long-term settlement and secure new leases. Direct quote, "We saw it as an encouragement for the tribes to negotiate in good faith with the plant owners on the outstanding issues," Modier said. "Without those leases, there's no certainty on a power source for CAP, and that affects water rates for our customers. We felt it was reasonable." I'm going to say the first one again. "We saw it as an encouragement for the tribes to negotiate in good faith with the plant owners on the outstanding issues." I'll let you interpret that as you wish. Kyle said, "Including the power plant and the water settlement ensured that CAP stayed on the table and agreed to include the 6,411 acre feet of water for Eastern Reservation communities." He said the Gila River Indian community, keep that in mind, whose water flows through the CAP canal, also wanted assurances that the Page power plant wouldn't close. All right, let's move on. And there's the river. I want you to put that in mind. Let's go to the next one. Jack Hastine sketched this some years ago, and he says, I thank the Navajo. Without their coal and water, we would not have half of this. I hope they don't find out. CAP irrigation water and Southern Arizona tribe. And what he's saying roughly is that the tribe got over 600,000 acre-feet in a settlement, and roughly half of that is from what I'll call local sources. Half is was originally CAP water, and he's a happy irrigator. Next one, please. Another Jack Hastine. Here's the proposed Navajo Gallup Winter Rock pipeline across state lines, raising a big hullabaloo. You can't transport your water out of basin and across state line. And it says Arizona, New Mexico, California, Colorado, Utah, APS, CAP, SRP, Peabody. Can't read that one. Only white corporations and non-Indians, farmers, cities, and states can do that. Something prophetic. This was done years ago, as far as I know. Denver, Colorado, you should know, they have the Continental Divide. A few years ago, they decided we've got to start pumping water from the west side of the mountains through tunnels to the east side so it doesn't go downstream and Navajo can't claim it. So they're working on that, and they've been doing it rather readily for about 7 to 10 years. And here we have Peabody that was in place forever, pumping across state lines. It was against state law to pump basin water out of basin, certainly out of state, but the state of Arizona passed a special law allowing Peabody to do this while it was happening. Next one, please. Another Hastine. I'm not the only one who put this together. I have those in-laws show up, and some of the older ones, 2 of them last night, chose this. As First Americans, we're concerned with the 4th priority part of the settlement, and you can see where the Navajo guy is in back. 4th priority is used a couple of times when you read the settlement information and in the 2010 settlement. It's a little too confusing to talk about now. The lower Colorado tribes are first priority. You can certainly read that in the court decrees U.S. Supreme Court established. All right. It's real important to try to see the right-hand side. Can we move the screen?
The right side?
Yeah, the right-hand side. Is it not showing?
It doesn't show up.
Oh, that's too bad. We can deal with that, though. I have an assistant. Will you start others? Let me have that one. Will you give the delegates each one of those maps, please? What you have here is Utah has for officially since 2006 has the Lake Powell Pipeline project in place. They want to get 100,000 acre-feet out of the upper basin. What you can't see, but does it show up on your screen, Nicole? Is there a lake over there?
Yeah, there's a lake on the side.
Lake Powell.
Yes.
So their pipeline, which is proposed now, they're before the Federal Energy Regulatory Commission, and you can pass it around to folks here too if they have enough. If they're taking water from near Glen Canyon Dam, across state lines once, this is upper basin, up through here, across state lines twice, down south of Kaibab, up across state lines again, and in the lower basin. Upper basin water to lower basin, crossing state lines 3 times. Now remember the previous cartoon, crossing that New Mexico state line once with lower basin water. I don't know why we're not getting upper basin water. There's about 100,000 acre-feet of extra nappy water available, or nip water. I don't think you folks knew about this. Any of you delegates know about this Lake Powell pipeline? I have the legislation right here in hand, passed in 2006 by the state. This is a big deal, and they're in a rush to get that 100,000 acre-feet before you do. and they're crossing state lines 3 times. They're taking 100,000 acre feet. I don't know why Navajo has to take pretend water from Phoenix that is obviously tied to encouraging Navajo to make certain decisions. Other people use stronger terms, and I might later. Okay, take a look at that as it passes around. The S2109 settlement agreement says at page 21, the Navajo shall have the right to divert and use any surface water from the Little Colorado River that reaches the Navajo Reservation. That reaches the Navajo Reservation. Let's look at this reaches word. It's from the late 1890s, actually, and it comes from the Winters case. What it says is the white farmers in Winters took all the water and said the Indians can use what reaches their reservation. How do I know they did this? From Fort Belknap. I used to ride with his father. This is fuzzy on purpose, and I'm not giving names. I used to work in Montana. I shot their horses and rode with them. We talked a lot about the Winters case, and I'm not giving names because in the past, some of my friends in different locations have been harassed by people from Navajo, when I give names. But his dad married a Salish Kootenai gal from Flathead, which is where the National Bison Range is. Again, the white farmers in Winters took all the water and said, quote from his father, the Indians can use what reaches their reservation. E.A. Fort Belknap, Ikea, Assiniboine, Grovant live here. This is the Milk River. This is where the Winters case happened. Now, the tribes used to have all of this northern unit of Montana, north of the Missouri River, practically all of it. In 1888, the res was reduced to this. And within a couple of years, white farmers began to move upstream. They kept taking water, kept taking water, kept taking water, till there was just about none reaching the res. So that's when the farmers said, and when the tribes complained and the United States complained, that's when the farmers said, well, the tribe can use the water that reaches them. They will have unlimited use to the water that reaches them. The United States didn't like that, neither did the tribes, so they filed suit with the U.S. Supreme Court, and the Supreme Court said, that business isn't correct. They have a reserved right for the future, for present and future use, based on 1888, the date the reservation was established. New farmers came. It didn't start coming until about 1892, and it didn't get going real strong till the late 1890s. Okay. For the delegates, have you ever seen this? Or anything like this? Okay. Hang on just a second. I can't keep taking books out of here, there's too many of them. This is one of 2 major reports. I could stack them up, they're a foot high. 2 major reports on Navajo water rights and watershed rehabilitation and so on, done in the, well, that's published in 1982. It is public information, U.S. Department of the Interior, and they addressed a number of potential water rights projects. Again, here's the box, it's full to the top. Don't hand it out, I don't want it to disappear if that happens. It's called the Morrison-Marley Report. There was another one called Williams Brothers. Who's seen Williams Brothers? Okay, one person. Okay, well, they both exist. Otto, Here is loop down here. There's loop. DA for Tulana Lake, Birch Springs. There's a proposed 20,000 acre farm found to be practicable. And I feel real bad because I'm generally not allowed to talk to people about Navajo water rights, past, present, or future, which is something wrong with that. And I was accused years ago, just by mentioning this, there was an attempt to fire me in 2001 for mentioning this public document. And people said I was divulging confidential information. Well, I wasn't. You can find this in libraries. There are not many of them because the volumes are so huge. DA 105,000 acre feet for this. In regional values, that's $420 million worth of water, retail value. I happen to be a regional reference. People call me about water values and marketers. I was on the phone with one the other day. Why? Because I got into this when we were selling water, CAP water to Phoenix in the 90s when I was Yavapai president. I have been called out to, over here would be Birch Springs, and these poor folks were desperate to put in a 20-acre farm, a 20-acre farm. I was not allowed to tell them, well, would you like a 20,000 acre farm instead? That's the way things are here. And I have to say thank you for directing me to tell the truth here today and what I know. This is just, like I said before, this is a beginning for a new dialogue, I hope Navajo nationwide. And you all are carrying that with you. This isn't the only thing. It wouldn't have a dam that dammed up the river. Here's a diversion works. You can't see it very well. But you all have a handout. You have a handout with this on it. Mine seems to have moved around. And you have other projects. These are others. Andy Morgan. Is Andy here? Andy Morgan worked on this and got an award in college for coming up with an irrigation program. These are based on soil analyses. Milton, you've done a bunch of these over the years, class 3, class 4 soils, sometimes class 2. These are technical things that have to be talked about when you're doing water analyses. The sad thing is, I'm not saying yay or nay to all these things, other than the loop farm is pretty practicable from the engineer's perspective, and the lift was only a few hundred feet, 77,000 acre lake. But people should know, this is that informed consent thing that the grassroots people, and I can't tell you how many of my relatives are angry with me for not being able to talk more openly about what I've seen, not just here, but comparing what I did for Yavapai Prescott and what I see going on here. Okay, next one. I think we skipped one. Go back and see if it takes a minute to show up. Do you see a picture on yours? Oh, okay. It was just integrated agriculture for these farms. There was a grain market, elevation and feed mill, elevator and feed mills, finishing feedlot, packing plant, processing plant, and distribution system, all tied in with a farm like the one at Loop. Okay, go to the next one. Now, in 1991, Lloyd Burton was a professor. He published this book. It's renowned in Indian country. I think you've read it, Irvin, before. Okay. Irvin Keeswood is very familiar with this work. He announced a Navajo, Colorado River Basin claim of 5 million acre feet. Let's go to the next one. In 1986, Bruce Babbitt, he wrote the foreword on this. Lawyer G. Weatherford and Dr. Brown published this famous book, for water people anyway, noting a probable Navajo, Colorado River claim of 5 million acre feet. Next one. Navajo Water Rights in 1980, Interior Attorney Doug Back and Navajo Nation Attorney Jeff Taylor both worked in Winter Rock, published a law review asserting the Navajo Nation could establish a tribal entitlement, that's a stronger term, to Colorado River Basin water of about 2 million acre-feet. I have to be honest with you, this was publicly stated. Mr. Pollock cited Back and Taylor in his 1999 and 2000 continuing legal education classes for lawyers off the res, and I have copies of those syllabi with me here today, explaining to outside lawyers the potential Navajo rights on the reservation after I referenced the same works. He said they were probably drunk and wrote this on a napkin in a bar, and that's paraphrasing. Let's go. So, I have a quote, this is from the University of Arizona, to be fair to Mr. Pollock, and in 1997, he said he could see a claim of no less than 5 million acre-feet. These are his own words, witnesses at the 75th anniversary of the Colorado River Compact meeting. Next one, please. Some officials have speculated on what the Navajo claim might be, noting two such publicized figures, about 2 million acre-feet and 5 million acre-feet, so there's a choice. Stanley Pollock, special counsel for the Navajo tribe, remarked that he is unable to figure a claim under 5 million acre-feet. Pollock referred to the Navajo tribe as a sleeping giant and viewed Indian water right claims as possible compact busters. Next, please. Because he is a central figure, we just have a few other people to reference. The University of Michigan, where I said that previous lawyer who wrote that concerned law review about the Arizona Supreme Court decision, same university, they did a nice article on Mr. Pollock, it's very complimentary, about his sacrifices, quote, for Navajos, and his sacrifices of living away from the city in the remote outpost of Winter Rock. I live away from Winter Rock, so I feel even remoter. But these are the sacrifices I think of, and when I say Shijay Naithna, I think of this, why it's been, some of you have done this to me, you know, some of my family members, you know what I receive when I go home. I am taught quite a bit and directed to think certain ways. Okay, the writer, after interviewing Mr. Pollock, reported the falsehood that state water law applies to Navajo, eliminating Navajo's rights. And that, this is a quote from the interviewer, virtually none of the reservation's 26,000 square miles is suitable for agriculture. Virtually none. It says at the top, RE treaty references, there's no question the reservation and allotments have a homeland and agricultural purpose. The Pollock article proved false instantly. Now, he didn't write it, to make that clear. But the Arizona Department of Water Resources director, also declared Navajos were not historically farmers. You know what would happen to me if I said that when I go out to places like this? I would not come back. All right. The Arizona Department of Water Resources reports that on average about 340,000 acre-feet a year flows into the Colorado River from the mouth of the Little Colorado River. That's below Blue Springs that became so famous recently, where the water's blue. 340,000 acre-feet. 160,000 acre-feet a year is Blue Springs. Now, I've been down there 7 times. I was not allowed to tell anybody. Do you believe that? If you read about it? Because there are certain people in central government that send word down, and you cannot talk about this stuff. That's your water. It rises on the Navajo Nation. And it flows at 2,000 water barrels. Everybody knows what a water barrel is? 2,000 water barrels a minute. And it's gushing out, and it's used, it's relied on by Arizona and the other states downstream for whatever they rely on it for. The United States generally divvies up the water once it gets in the mainstem. So about half of what flows comes from Blue Springs, which is 12 miles upstream from the Colorado River. And the other half is the darker water that's full of turbidity, muddy, from storm flow and light rains and runoff. Next one. We're getting close, folks. This is a primer on water values. It's very important. You all have to be able to go out from this point and build on this foundation. That's all it is. It's just a baseline foundation. Ownership versus lease. It's like a car. You can own a car, you can lease it. You can own water rights or you can lease them. There's retail value, there's wholesale value. It's really not hard to figure out. Value is based on location. You heard that about real estate. Location, location, location. Albuquerque, surface water ownership, right in Albuquerque, $35,000 an acre foot. That's ownership, not leasing. Just above, it's $25,000 an acre foot. These figures are actually about 5 years old. And just below, about 25,000 acre feet. You've been to Santa Fe, not a whole lot of surface water there. Surface water rights in Santa Fe several years ago were $55,000 an acre foot ownership value. NIP, NAPI and NIP, when I testified before the council once, it was very restrictive. You might recall, I was using very conservative figures. I said, well, $1,000 an acre foot would be a reasonable, I said it's conservative, sale price for water, and leasing 200. Let's see. Crazy white man, I think is what I was called. In less than a year, NIP water, Navajo Agricultural Products Industry, NIP water, when I said, all right, I'll say 1,000, I'll be conservative, one of the best farm appraisers in the United States said $15,000 an acre foot. The land and the buildings at NAPI NIP were worth, in the appraisal, just over $1 billion. The water, $4.2 billion. Water is worth more than the coal, oil, gas, and gaming combined. And when you get a chance to pick that up, it's not a lot of light in here, but they call it blue gold. This is from a few years ago. It says it's liquid gold rush in Arizona. And this is when these guys got their settlement. And that's where Jack Osteen got his idea about his cartoon, Navajo pumping half that water to the tribe that now has a voice in the state's future. Yeah. All right, Colorado River water in Las Vegas. Officials of the Navajo Nation, administrators, were offered $10,000 an acre foot. They couldn't do it, of course, for a long-term lease. So imagine the value of that water that's gushing out of Blue Springs that Navajo said, that is ours and we're going to keep it. We're going to negotiate as hard as we can. That would be $1.6 billion for long-term, which is usually a century, long-term lease. Peabody water, $3,500 an acre foot. Isn't that true now? Didn't Resources Council pass that? And Navajo Nation industrial water use fees right now, Resources Committee made those $1,300 an acre foot. So if Navajo Generating Station were to pay the fees that now exist, they're on the books, industrial water use. That's $44 million a year. If Navajo just gave away the coal and charged for the water, Navajo would make $12 million more than it did on the coal, I think last year or the year before. It was $32 million. Water is worth more than coal, oil, gas, and gaming combined. Okay. I think I've made my point on values. I don't want to talk more. Navajo Generating Station has used $1 billion worth of water in 30 years, and estimate of mine does not address that. There's law on the books requiring them to pay, but it's not been enforced. Okay, I'm going to insert something here. I arrived here from Yavapai Prescott, where I'd done water work over there, water rights settlement, and was hired by my good boss, Benny Williams. I'd been here a couple of weeks. I met a few of the folks. I met a couple of the water rights people. In 2 weeks, I realized something was very, very wrong here. Unbelievably wrong. And I began to talk to some of the administrators. There's Arvin Trujillo, Robert Allen, Sharon Knoll, she was chief of staff. Kelsey Begay listened. Ed T. went along with Kelsey. This is the national expert on Indian water rights settlements. Dan McCool. Leonard Gorman is looking at Levon Henry over here, who refused to have his picture taken. Charles Wilkinson, David Getches. David recently passed away in a hard death. Over there is the law book that these two guys publish, and the history of Indian water rights settlements that he publishes. I was talking to a couple of folks here. I can't say exactly who, because then they'll be harassed. And I said, you know, this is not what I experienced in Washington. This is not what I experienced with CAP, the state, with the tribe, with the federal negotiating team, with PIA, and so on and so forth. And they said, all right, well, what do you propose? I said, let's have a seminar for the whole council and the president. Well, somehow they approved it. But we were not allowed to bring these guys to Navajo. People from DOJ refused to let us have national experts come and talk to the council and the president at the request of the council and the president. And that made me wonder, who's in charge of this place? I was a rookie then. I was new. However, I was told to keep at it, so we left the res. We flew to Boulder, Colorado. This is in May of 2000. And this man, now deceased, was a brilliant guy. They all are, the three presenters. He was the leading expert on the law of the Colorado River. They both have that federal Indian law textbook, and he has, again, the history of Indian water rights settlements. And we had a 2-day seminar. At the end of the 2 days, Charles said, Mr. President, would you like a recommendation? And he said, sure. I'm going to tell you verbatim what he said. File immediately for 10 million acre feet on the Colorado River. Every passive day is a negative day for the Navajo people. We came back, nothing was filed for. It was the end of it. And this is the only time I've been able to talk about this publicly in those 12 years. By the way, next slide, please. Vine Deloria, you guys know who he is? Vine Deloria Jr.? Again, Yada Dolphin. Okay. The greatest American Indian scholar of all time. He said, you guys are jerking me around, Jack. He called me on the phone. You're changing these meetings. I said, we're not allowed to have them on the res for some reason. I said, we're going to try to get up there at Boulder. He said, when? I told him, he said, I can't make it. But he called me 2 days after this seminar and endorsed everything his colleagues said. And he's since passed away. I will also mention that although I felt good about what happened up there, nothing happened down below. And then a smear campaign started down here. And then those guys, after a while, called me. Not him, he didn't do that. He never did. And dropped me, and I think the Navajo people like a hot potato. There were people calling around. Now, there's a tab on the side of the book. It opens to page 239, and I'm briefly going to read from the Standing Bear case. Standing Bear is the man on the front of the book. This is one of my teaching books, American Indians Answers to Today's Questions. It's published by the University of Oklahoma. So the Standing Bear case is a very famous case, and I'm tying this definition to what we've seen come out of the Arizona Supreme Court and what's being applied through ST-109. Webster describes a person as, quote, this is the court talking, a living soul, a self-conscious being, a moral agent, especially a living human being, a man, a woman, or child, an individual of the human race. This is comprehensive enough, it would seem, to include even an Indian. I must hold that the Indians are persons. That's the Standing Bear case, famous federal court case, district court case from May 12, 1879. And that's part of why people have talked about the human rights issue of S2109. There have been some complaints filed, and I suspect more will be filed. Good. As I say here, that's okay. I'll go back to the last one. Some Navajos have raised related issues, saying it's a step back more than a century to have this kind of language applied to Indians. Now, where does this come from, this human rights concern? Go to the next one. And I'm specifically related to eventually those couple of court cases that the state Supreme Court misinterpreted. Where is some of this human rights concern coming from, beyond the informed consent question? It's coming from how the Arizona Supreme Court misapplied two important U.S. Supreme Court cases. I'm not alone in this, by the way. I'll reference a law review article from a lawyer from the University of Michigan. The pair is the first case. It involved Devil's Hole in Death Valley. There's some little ancient fishes that live down in that crevice. That's groundwater and surface water both. It's kind of confusing. Next page. Devil's Hole desert pupfish, a rare curiosity. It's about 2 inches long. These were determined in the compared case before the U.S. Supreme Court to have a minimal need for this fish for the federal water right reserved for their preservation. Okay. The next case that the Arizona Supreme Court interpreted, and you should know that it interpreted these cases, I thought, correctly in the beginning when they started, and then flipped them toward the end of the decision. In United States v. New Mexico, the U.S. Supreme Court said the Gila National Forest in southwest New Mexico merited a minimal need right. So we have minimal need right for fish and the forest. However, the Supreme Court said in its footnote 4 of the New Mexico case, it was distinguishing Indian reservations from other reservations. How many veterans in here? Okay. You were all on reservations, military reservations. That's a federal reservation. Who's been to a national park? Okay, that's another reservation. National forest, another reservation. Those are federal reservations. Indian reservations are different. And the Supreme Court made that point in the forest case. In footnote 4 of the New Mexico case, the Supreme Court distinguished Indian reserved rights, as addressed in the Winters case, which we'll get to shortly, as a reasonable quantity of water. Not a minimalist approach, not a minimum amount, a reasonable quantity of water. Again, rather than a minimalist quantity. So, minimal need has been applied by the U.S. Supreme Court only to fish and a forest, not to people. That is why this minimalist approach, so obviously applied in the LCR settlement, is a human rights issue. I need to make very clear, I am only speaking for myself and hundreds of in-laws in 40 to 50 chapters. That's all the people I'm speaking for today. It says native lawyer. Yeah, there you go. Native lawyer Galen Nemai, I think that's how he pronounces his name, talked about the Arizona court's minimalist approach. Again, he went to the University of Michigan. Tribes were robbed of most of their land long ago. Now the Arizona Supreme Court reasons they should also lose the right to the water necessary to reap the full benefit from the land they have left. It is unfair. It gives tribes a shadow of what they had before. The tribes are the losers. Questions I've received since a couple of days ago. What is today, the 15th?
Yeah.
I may have meant April 14th. I think that's what I meant. It was late, and my friends were talking to me. Questions I received since Valentine's Day, we make it that. Aren't the S2109 groundwater projects already a trust responsibility? One question. Why are the NGS and then, that's Navajo Generating Station, and then the CAP water, Central Arizona Project water, for Window Rock in S2109? Third question, isn't the S2109 settlement really for them? Now, a number of you in here have asked those same questions. Well, about the first one, Congress declares for the Indian Health Service and the legislation for it, it is in the interest, direct quote, of the United States and it is the policy of the United States that all Indian communities and Indian homes, new and existing, be provided with safe and adequate water supply systems and sanitary sewage waste disposal systems as soon as possible. And that's been on the books for decades. A review of the basic revealing stories of the Central Arizona Project and Navajo Generating Station. So central to S2109, where it's presented now. Navajo Generating Station is the key to CAP, Central Arizona Project. NGS, Navajo Generating Station, is not Navajo, either in ownership or in who receives power. Water use is 34,100 acre-feet a year, which is in regional lease prices worth $34 million a year. The total used since the mid-70s, early to mid-70s, in today's dollars is $1 billion worth of water. There will be no change to this as S2109 is presented. This is how Jack Lahastine visualizes CAP's function. Navajo coal and Navajo water come together at Navajo Generating Station and create electricity. 23.7%, roughly 25%, 23.7% of the power from NGS has always been dedicated to Central Arizona Project. When I first came here, actually I first came here in 1956. And I've said to some of you, yes, I'm that old. But I was in a 56 Ford, I was not driving. But when I first came to work for the nation in 1999, nobody that I talked to knew about this. It rather stunned me. And this power has come down here, and it takes, it can take up to 1.8 million acre-feet. They haven't reached capacity yet. Down to Tucson, about 336 miles. All of these tribes have rights to Colorado River water through CAP. I work for this tribe, Yavapai Prescott. Yavapai Prescott is over a mile high and 180 miles from the river, several thousand feet above the CAP. It was impossible economically to get water, CAP water, to Yavapai Prescott. We didn't care. We negotiated for it anyway. And for that little tribe, 160 members, less than 1,500 acres, we got 500 acre-feet of CAP water. Paper water, paper rights. You hear that all the time and you're told it has no value. Well, let's give a comparison. Little tribe, 160 members, 500 acre-feet. Navajo's over 1,000 times bigger. That would be like Navajo getting paper rights to over 5 million acre-feet of water. Closer to 6 million. And we sold that. You're not supposed to, and I always say you don't sell any water rights, but not everything is black and white. We sold that water to Scottsdale for $500,000. 1,000 times $500,000 would be what Navajo could have got if the situations were reversed for water it could never receive. Paper water has value. It's like the title to a car. Don't let anybody tell you differently. Get all the paper water, is my view, this was our view over at Yavapai Prescott, and wet water you can, because it all has value. if you accumulated all of the water we got, it was about 1,500 acre feet, that would be over 15 million acre feet for Navajo, and I believe, if my math is correct, and I'm not great at math, the CAP water would have been equivalent 1,000 times higher for a res this big, $50 million. We didn't have what Navajo has more of than anybody else. The most valuable resource that Navajo has for S2109 or anything else regarding politicians is votes. The votes are not, and the voting block of Navajo is not managed very well, but it's hugely valuable. What our tribal president, Patricia McGee, some of you may have known her, did was she strategized very carefully. Bruce Babbitt became our water rights attorney. For that little tribe, we had 3 water rights lawyers. And then the head of the local, and of course Bruce is a Democrat, the head of the local Republican Party was our local judge for the tribe. And you don't know this maybe, but Yavapai County is a mecca for Republicans nationwide. They like to go to the courthouse steps where Barry Goldwater started his presidential run, and we have other people do that from time to time. Navajo, for some reason, is unable to master the power it has, as well as some of the smaller tribes. But I think Navajo can. I think it has far more power it can exercise than has yet been discovered. Okay. You all have another handout. I don't want to stay on this too long. But these are articles that came out in the Navajo Times and the Gallup Independent in 1969. And the headline says, "The net deceived for decades, 1969 water rights news just like today's." Here's a quote from the editor. Some of you may have known him, Chet McCory, Navajo Times, 1969. "The Navajos possess inestimable potential values in their water, which they could promote for untold millions of dollars in years to come from those who want it so badly now." Now that's 1969. One of my favorite quotes of all time is on this paper. It's from Frank Luther. And they were debating whether or not to waive rights to the Upper Colorado River, and he was all for it. Annie Dodge Wanika said, "Wait a minute, this is too confusing. I don't understand all this. I don't think you all do either. So let's think on it for at least a few days." They did, but the waiver happened anyway. Here's what Frank said. Very telling words. In the council. He did not like the people getting in the way of the waivers. If the Navajo tribe wants to give away its water rights, it should not be interfered with, Luther said. He also told the council he was from the copper mine area and the people there don't want the water. Quote, "Since it just runs down a deep canyon and makes a lot of noise." He didn't understand water values. And I did want to read one more thing. It may be marked on your handout, but I'll read it anyway. It'll be in the lower right hand, a couple paragraphs. This was from the DNA lawyers back then. "There is no reason why the Navajo should give away their water to irrigate southern Arizona," Mitchell said Wednesday. He was the DNA attorney. "There is land on the reservation the Navajos could irrigate themselves if they had the water available." Mitchell also forecast political opponents of the Navajos retaining their water might do everything in their power to prevent the refunding of DNA. That was a side political issue. "Our sole aim in this," he said, "is to protect the Navajos' water rights. Actually, this should be a reasonably responsibility of the legal department of the Navajo tribe instead of aiding in the giveaway of those rights." Mitchell also charged the tribe's legal department acted in collusion with Interior Department and Arizona Public Service attorneys in preparing resolutions waiving the tribe's water rights. So, 1969 news. can skip over 2 more. And we'll come to a vote. Next one. Yeah. Bear with me. 2 things you're not supposed to do. I teach public speaking sometimes, but I haven't for a few years. You're not supposed to give handouts. You guys remember that? And you're not supposed to read. Well, bear with me. This is so important. And this issue's been going on so long. Bear with me while we read just a couple of pages from Fradkin's work. It's a source of Navajo Water Rights history. This is disingenuous. I don't know what the Navajo word for that is. Deceptive is the English word. You're waiving claims to rights. We're not waiving rights, we're waiving claims to rights. You've got to finish the sentence. What it is, the rights are being waived beforehand. There's 100 sheep out here wandering around, and they have there's a half a brand, Navajo brand on them. And somebody's going out there and saying, I'm deciding only to bring 2 to the table and let the other 98 go. Here come the 2 sheep of rights, the 2 rights sheep. The others are gone. I'm not waiving rights, they're right here. I'm waiving claims. The other 98, it's claims to rights to the other 98. It's an interesting way to put words. I'll put it, yeah, go together. I don't know what you would like to do, because I learned about this last night. And I'd be happy to answer your questions. I know we've been here for a while, but this is, you can tell, this is 5 decades of stuff. At least, we've covered in a very short period.